Welcome, welcome to our October Colera meeting virtually. Thank you so much for joining us. Today, we are going to have a set of updates about recent National Labor Relations Board case decisions that are some important ones. The speaker is going to be Naomi Clark, who is a supervisory attorney in Region 9, which is actually the Cincinnati, Ohio region, if you've not seen her speak before. She actually has worked for the National Labor Relations Board since, I believe, 1995, first working in their Buffalo office and then transferring to Cincinnati here in Ohio. She has been responsible for investigating and litigating unfair labor practice cases in the private sector, presiding as the hearing officer in contested representation election cases, and serving as counsel for the NLRB in federal district court proceedings. She actually now supervises a team of field attorneys and field examiners in performing the same activities. So she is going to be our speaker today. With that, I will turn it over to you, ma'am.
Thank you, Christina. So I guess a couple more things about me. Maybe if people were paying attention, they saw that bag of Doritos on my desk that I didn't know was could be seen in the screen. I don't eat Doritos for breakfast. Uh, Occasionally for lunch. Most of the time I like Cool Ranch, but the store didn't have them. So, and then also I had to get them so I could spend $4 at our cafeteria here and not have to pay 35 cents because my what I had purchased, which was that Pepsi you guys saw me sipping on in the water, didn't come up to $4. So just a little bit, a little bit of non-useful information for you guys. Um, Also, thank you, Christina, for that introduction. And this is not on you, it's on me because I think I maybe didn't send an updated bio to you because this is the third time I've come here to speak to Colera, and thank you all for inviting me back again. I was promoted to regional attorney last September of 2023. So
Congratulations.
thank you. That's a great segue to sort of to my introduction because I wanted to give for those I know a lot of you all probably do practice in labor and employment. For some who are heavier on the employment law side and not as much in impairment for the board. Although I just wanted to sort of give you just a very brief um primer on what I do and how that fits into the scheme of the board. So today I'm going to be covering um, board decisions, seminal board decisions. I, as a regional attorney, I work in the field office, and the field offices come under the general counsel's authority primarily. There are some duties that are delegated to the regional director that are delegated by the board, but primarily or by and large, what I do here and what we do in the field falls under the general counsel's authority as the prosecutor of the agency. She's a presidential appointee. The board panel board members, 5-member panel. They are also presidential appointees. And some of you may know that traditionally a majority of the 5 seats are traditionally held by the same party who holds the White House. So it is not uncommon for those of you who are familiar with the history of the board for some doctrine, some cases, for there to be some back and forth between different presidential administrations, depending on which party is in control of the White House. I'm not here to debate which interpretations by any certain board are more right or wrong, but really more to tell you where the law currently stands based on the board, the current board. So there's my other intro. I do not have a PowerPoint presentation. I'd love to just be looking at all of you all's little avatars and be able to remember all of this just right off the top of my head. But I am going to be following an outline here. So instead of, having you all, look at me while I can't look at you, kind of be looking down like this at my outline. I am going to put up a visual. I like visuals as well. They help me. It's not a PowerPoint. It's literally just the press release is issued by our Office of Congressional and Public Affairs, which can be found on our website at www.nlrb.gov, which is a good resource to keep up to date when the board does issue these decisions, especially ones, you know, that change standards. You can subscribe actually to get weekly emails to receive weekly from the board, weekly decisions that are issued by the board and the administrative law judges. And you can also find these press releases. So sort of that'll keep you up to date. But this will also give you something to read and kind of summarize some of what I'll be talking about here today. So let me go ahead and share my screen. And I don't mind toggling in and out. Before I get going, I want to make sure that the way I have it showing here is working for everyone. So maybe the tech person can tell me if I need to make any adjustments.
Looks great.
Okay, cool. Oh, wait. Is my face is still up as well as my materials? Is that how we're doing it?
That's the way it shows, I believe.
Okay. All right. That's
And
fine.
if you want, I think you can make it just a little bit larger on your Adobe screen.
Okay.
I believe there should be a function either at the very top or at the very bottom that
Yeah, it
like,
was just waiting for me to click
there you
that
go.
to say, okay, to this meeting is being recorded. Uh, okay, let
There in the
me,
middle, there's the plus sign.
yeah. How's
There
that?
we go.
Okay,
That looks great.
let me scroll up a little bit, so maybe it's all the way in. Um, okay, so yeah, guys, I'm okay with you guys not making eye contact with me as long as you're okay with me not making eye contact with you, because I'm gonna be kind of looking at my outline by and large. So I came up with what I thought was sort of this witty title of the August board, because what I'm covering kind of goes August to August. And there is quite a bit I discovered as I was preparing for this. So a big part of my time is going to focus on the PCA, the cases that deal with PCA, how it's defined, and how it's been defined by the board, because some of those, and that also under that employer handbook rules fall under that category. So that was a pretty interesting subject in those cases, especially the facts are pretty interesting. And then in another category of cases, dealing with Section 885, particularly the board addressed statutory duty of employers to bargain with unions. I'm going to spend a little bit less time on that. And there are a couple of rules, significant rulemaking that the board engaged in here. Some of you may know that historically the board makes law more by adjudication rather than rulemaking. That has been the subject of criticism, but while in the last 4 or 5 years, it's sort of done just the opposite in the area of rulemaking, at least with respect first to the rules governing representation elections. And then it issued a rule, actually 2 rules, on to determine joint employer status, which had long been just the subject of jurisprudence. And I'll give you a little spoiler alert here. Its attempts to amend those rules in August of 2023 was ultimately that rule that it issued rather in October of 2023 was ultimately challenged in a district court. District court initially stayed enforcement of the rule or enactment of the rule, and then ultimately vacated the rule. And so the board eventually, just this past July, decided to withdraw from that action after considering what steps it would take in light of the board vacating the rule. I'm sorry, not the board, the district court vacating the rule. So that is kind of in limbo. So yeah, a little spoiler alert there, but I'll just briefly touch on sort of what the standard has been under board law, which was also going back and forth based on the composition of the board. So where that might be, if in the event that you are handling a case and that issue comes up before the board, I can at least point you to where you should go. Okay, so the first set of cases, the board dealing with how protected concerted activity is defined, what is concerted, and what is mutual aid and protection. Those are the two elements of defining protected concerted activity. And let me back up a little bit. Section 7 of the Act, which is the heart of the Act, protects employees' rights to form, join, or assist a labor organization, to engage in activities for the protection, for mutual aid and protection. I'm just sort of paraphrasing here. So not only does it protect employees' rights to form unions or to join a union or to not join a union, it also protects other group activity or group action where employees work together for their own mutual aid or protection. I can tell you that of late, so that sort of piece of Section 7 has been the subject of lots of charges that are coming, at least into our regional office. I don't know if the same is true across the country, but more and more members of the public are learning that the Act comes into play not only when there's a union involved, but also when there is not a union involved. So how we define what type of conduct, how the board defines that, has been the subject of debate between boards over the last 6 or 7 years. So one of the areas that the board has, some might say, stuck its nose into, but the board is clear that it has the authority to do so, is employer handbook rules. And whether or not those employer handbook rules restrict or chill employee Section 7 rights. Now, some areas are easy, right? When the rule explicitly restricts it, that's easy. Rules barring discussion of wages. Very clear that those are not lawful, okay? But we're talking about rules that appear to be facially neutral, rules that prescribe or regulate conduct, uncivil behavior, disparagement of other employees, disparagement of the employer, confidentiality of investigations by the employer. Those types of rules that don't specifically mention Section 7 or the type of activity that might be protected by it, but that might chill it. So in Stericycle, which is the case I have up here now, the board adopted a new standard to decide whether such rules that do not expressly restrict employees' protected concerted activity under Section 7 are facially unlawful under Section 8A1 of the Act. And in doing so, the board reversed Boeing, which had been decided in 2017 under a prior board. And in that case, the Boeing board, sua sponte, reversed the standard that had been announced in 2004 in a case called Lutheran Heritage Village, Livonia. And I'm happy to provide a listing of all of these cases, the citations after the presentation. So that should go out later if anyone has questions about that. But Lutheran Heritage Village. So that case, we all live with here at the board for 13 years before Boeing became law. And in Lutheran Heritage Village, the board said that if a rule does not explicitly restrict Section 7 activity, a violation is dependent on a showing of one of the following. Number one, employees would reasonably construe the language to prohibit Section 7 activity. Number two, the rule was promulgated in response to Section 7 activity or union activity. Or three, the rule has been applied to restrict the exercise of Section 7 rights. So again, here, the second and third categories of cases, rules is pretty easy, to analyze, but it's that first one, whether employees are reasonably construe the language to prohibit Section 7 activity, that poses the biggest challenge for the board for determining whether a rule is unlawful. In Lutheran Heritage Village, the majority instructed that the board must refrain from reading particular phrases in isolation and must not presume that a rule will cause improper interference with employee rights, and should not conclude that a reasonable employee would read a rule to apply to Section 7 simply because the rule could be interpreted that way. So it's sort of, the board articulated a reasonable person standard is what they're saying here. How would a reasonable employee construe the rule? Sort of implicit, seemingly, to this standard that was articulated in Lutheran Heritage was a consideration of the employer's countervailing interest in regulating the conduct that the rule addressed. But under this Lutheran Heritage Village case, the board went on to strike down a hospital employer's rule prohibiting conduct that, quote, impedes harmonious interactions and relationships, because employees will reasonably understand that it could encompass interactions protected by Section 7 activity. It also found in another case that a rule prohibiting negative or disparaging comments was unlawful because it would reasonably be construed to prohibit protected expressions of concern about working conditions. So, yeah, you got to have thick skin for these for these board decisions talking about rules. Quite honestly, for those of you who, maybe go back and look at some of these cases, you'll see these rules and you ask yourself, how can this be bad? Why is this bad for an employer to want harmonious relationships, or for an employer to say, hey, it's you could be disciplined if you are disrespectful to coworkers or disrespectful to management. So those are actually the types of cases that have been found by the board, as you can see, to interfere with Section 7 activity. So under Boeing, which overturned Lutheran Heritage Village, the board said that when deciding the lawfulness of maintaining a facially neutral rule, the board would evaluate two things: the nature and extent of the potential impact on rights under the act, and legitimate justifications associated with the rule. So therefore, what the Boeing board said was Lutheran Heritage Village didn't explicitly account for the employer's interest in the rule and in regulating the conduct that the rule seeks to regulate. And so it made that explicit. It took another step and actually created this category, or articulated this categorical classification system for rules. There were three categories. One being rules that are always lawful to maintain, two being rules that are sometimes lawful to maintain, and third being rules that are always unlawful to maintain. So lots of direction there. But under that rule, so one of the issues was the rules involve use of cameras in the workplace. And the board held that that rule was lawful because any adverse impact on Section 7 rights was comparatively slight and was outweighed by important and substantial justifications associated with Boeing's maintenance of the no camera rule, such as the obviously Boeing makes airplanes and they don't want their employees inside and on the work floor taking photos of their production process and other manufacturing or secrets, trade secrets, or things that may be used in their process. So they said that the rule was lawful. They also went farther and categorized the no camera rule in general as always being a lawful rule. So they placed it in category 1. They also designated all rules requiring employees to abide by basic standards of civility as always lawful. And they found that under a later case decided under Boeing called Apogee Retail, that investigative confidentiality rules limited to the duration of the investigation are also categorically lawful to maintain. So that's what was happening under Boeing before Stericycle was decided. In Stericycle, the problem that the board found was that under Boeing, it pretty much, they believe, gave employers more free rein to adopt overbroad work rules that chilled employees' exercise of their rights under Section 7. And failed to take into account, one, the economic dependency of employees on their employers and their wish to avoid discipline or loss of employment. And secondly, that it condoned overbroad work rules by not requiring the drafter of the rule to draft a most narrowly tailored rule to promote its legitimate and substantial business interests. So the new standard under Stericycle is that first, the board will begin its analysis by assessing whether the general counsel has established that a challenge rule has a reasonable tendency to chill employees from exercising their Section 7 rights. And of course, in doing so, it will interpret the rule from the perspective of the reasonable employee who is economically dependent on her employer and thus inclined to interpret an ambiguous rule to prohibit protected activity. That's pretty big because in reading some of these rules, you may say, well, one employee is going to think that. One employee is going to think that a rule that promotes civility or harmonious relationships is going to think about the act or even be aware of Section 7 activity and what the act protects. And that standard says that they don't have to be. It simply means that they are what the board is recognizing here is, as an employee may be in the workforce, they may want to talk about wages. They may have a criticism of a new policy. And even if they may not know the act protects their right to go to other coworkers about it or to join with coworkers and complain about it to management, they know that there's a rule that says that you have to behave, work harmoniously, or you can't criticize, or that's not harmonious, or it's not positive conduct. And so if there's someone who's really doesn't want to risk losing their job, they're going to err on the side of not engaging in that activity. If the general counsel is able to establish that the reasonable employee would interpret the rule as restricting Section 7 activity, the rule will be found to be presumptively unlawful. The burden then shifts to the employer, who may show that who may prove that its legitimate and substantial business interests cannot be accomplished with a more narrowly tailored rule, and that as a result, the rule should be deemed lawful to maintain. So that's Stericycle. Stericycle involved a confidentiality rule investigations, which means that it was a rule that said you may not discuss, certain matters that are under investigation by the employer. You may not discuss with coworkers. You may not disclose what's going on or your discussions with management to coworkers. And as I mentioned, Boeing said that categorically that was always lawful. In this case, the board said no, now it has to be examined under Stericycle, under the standard that they articulated. And so the case was remanded to the board to do so. I checked, and so far we do not have a decision that's been issued or supplemental decision issued by the ALJ in that case. So remains to be seen where the board will come out on those rules that require confidentiality in certain investigations. Those come up a lot, particularly in sensitive investigations, like those involving allegations of sexual harassment or other type of harassing behavior. So we'll see what the board has to say when that makes it back up to the board. A couple of takeaways here. There are some types of rules, I guess you could call it, well, one thing to remember when it comes to rules is that certain types of rules are already the subject of board jurisprudence, where the board has sort of spoken on these particular types of rules, like no distribution and no solicitation rules. I mean, that's long established, not just the board, but that's gone all the way up to the Supreme Court for what is and is not lawful with respect to solicitation and distribution. There's also the use of employer equipment that the board has held in a case called Caesar's Entertainment, that employers may lawfully restrict use of their equipment, electronic communications, and resources, as long as there is no evidence that it was done for discriminatory reasons. So the board that's not a categorical approach, but the board in Stericycle specifically said that Stericycle does not apply to cases like that, where the board has actually spoken on special or certain types of rules. Same holds true for off-duty access by off-duty employees to the employer's premises. There are a long line of cases that address that issue. Okay, I'm going to move on. Moving into, so there's 3 cases I'm going to move on to next, and I see how long it took me to do Stericycle, so I'm going to try to pick it up here. So there were 3 other cases decided in August. Miller Plastics Products. So you're not going to be able to see all 3 of these. Okay. Miller Plastic Products, American Federation for Children Incorporated, and Home Depot. And a lot of you maybe have heard about Home Depot. That case, some people call that the Black Lives Matter case. So I'm going to get to that. Let me start with Miller Plastic Products, Inc. So this case specifically the board examined the issue of what is concerted. And more specifically, the question was about activity where an employee speaks directly to their employer in a group setting, meaning in the presence of coworkers. So that's really where that case comes into play. So the question is, a lot of times you have meetings where it may be a formal meeting, like a meeting called by the company, or it may be informal or less formal. It may just be a group setting, but it's not a meeting that's specifically called by the company. And an issue surrounding terms and conditions of employment comes up, and an employee asks a question about it, or maybe challenges it, or says you shouldn't do this. And the question then becomes, was their activity concerted? So Miller Plastics answers the question with a resounding yes. Prior to that, the board in Allstate Maintenance, a case called Allstate Maintenance, which was decided, sorry, I don't have the site in front of me, but it was under the prior board. Just in case you haven't caught on to the theme here, all of these cases, the board intended to reverse what they saw as improper adjudication or wrongfully decided, not improper adjudication. That wasn't the right way to characterize that. Cases that were wrongly decided by the prior board. So in Allstate Maintenance, the board said that an employee who makes these sort of statements or raises these issues in a group setting is not automatically engaged in concerted activity, that there has to be, that there are 5 factors that must be met to sort of create the inference that they were engaging in concerted activity. Just real quickly, concerted activity has been defined in Myers Industries cases. These are seminal doctrine establishing cases. You'll see them cited all the time for what constitutes concerted activity. There's Myers 1 and there's Myers 2. So I'll just tell you that in Myers 1, the board said an employee's activity is concerted with is engaged in with or on the authority of other employees. So that's typically where you have either it's automatically a group speaking, or there's proof that the employee got the consensus of the group and they spoke up on behalf of the group. And then secondly, in Myers 2, the board clarified that concerted activity encompasses circumstances where individuals seek to initiate or to induce or to prepare for group action, as well as individual employees bringing truly group complaints to the attention of management. So it's not always as easy as it sounds. When you have a lone employee acting, how do you decide whether or not their conduct was concerted? So in Allstate Maintenance, the board set forth this 5-factor test. In that case, just real quickly, because it's kind of interesting, that case involved a group of sky caps who had been told that this soccer team was on their way to the gate. Well, not the gate, they were outside at arrivals and they were coming in and they needed them to be ready so that they could take their bags and get them to be loaded and everything. So one sky cap complained that he didn't want to wait on these guys because they were terrible tippers. And he complained about their bad tipping and that they were rude, and he didn't want to go wait on them. And I think he was subsequently discharged. In any case, the board found that this individual's conduct was not concerted, even though he raised it. There happened to be several other sky caps standing around when he raised these concerns to his manager and when he refused to assist the soccer players. But the board said that in Allstate said that that wasn't enough to render it concerted. So they set forth this 5-element standard, which really quickly required that one of the 5 was that the statement needed to be made in an employee meeting that was called by the employer to announce a decision affecting wages, hours, or some other term or condition of employment. And the employee who speaks up in response to the announcement did so to protest or complain about the decision, not merely to ask questions about how the decision has been or will be implemented. So those are 2 of the 5, and those are the 2 that in particular the board in Miller Plastics sort of attacked and pointed out as being wrong. So obviously in Allstate, that was not a formal meeting. And so the board found that it was not concerted on that basis. It was more impromptu, and it was more akin to personal griping by this employee and was not a group complaint or concern. The board in Miller Plastics reversed that and said that those 5 factors were way too restrictive. and did not recognize longstanding principles surrounding what is and is not concerted activity. And so it dispensed with that one. And in doing so, it also reinstated and said it was correctly decided a case called Wyndham. Again, I'll give you all an outline. And that case, facts are always funny in cases to me. That case involved an employee who complained to a supervisor about employees having to tuck in their shirts. And it was not obviously in a formal meeting. He went and confronted the supervisor and said, hey, what's up with this new rule that's coming out? People don't like to tuck their shirts. And so he did. The tucking in shirts, the facts established was a concern of more than just this individual employee. And even though it didn't take place in a formal meeting, it was more in a setting that was impromptu, and there were a couple of other employees present. That was enough to render it concerted. And just keep in mind that I'm giving very sort of blanket overview here, so you'll want to take a look at some of these cases if these issues do arise. In Looking at the time here, American Federation for Children. So the question there was, what is mutual aid or protection? So there are two elements, again, to protect a concerted activity. One being that it's concerted, and number two, that it be for mutual aid or protection. So American Federation for Children deals with that question. And there, the board returned to longstanding precedent. These statements are being released by the president board, so you can understand why they say call it longstanding precedent, that concerted advocacy by statutory employees on behalf of non-employees is protected by the National Labor Relations Act when it can benefit the statutory employees. So that case involved an employee who worked. The employer wasn't or is a school choice advocacy nonprofit group, and the discriminantee in that case, whose last name was Raybon, she worked for them. And at this case involved she got a new manager, a new supervisor whose name was Smith. So for ease of reference, I'll just use names here and last names instead of saying sergeant party, supervisor, manager, etc. But so anyway, at the time that Smith arrived, their pending was a application by a former employee whose name was Asensio. I hope I'm pronouncing it correctly. Anyway, Asensio, her employment with the employer had ceased in 2017 because her work authorization, she was working under work authorization because she wasn't a US citizen, had expired, and she was applying for reauthorization. The employer really valued her. The facts established that the other workers valued her, and the employer was assisting her. They were sponsoring her again for a second reauthorization, and it was still pending. So while it had been pending for a while, and while it was, the office that Raybon worked with got a new supervisor, and Raybon questioned whether or not this new supervisor remained committed to rehiring Asensio, just based on some conversations that she had had with him. She also ultimately developed concerns that he was anti-immigrant. One of the things Asensio did was reach out to their Hispanic constituents or audience. And so this particular person, Smith, had formerly been an Arizona state senator. And so she also complained about the fact that he had sponsored anti-immigration legislation. So Raybon, these complaints and discussions took place over a period of time of several months. She talked to, her activity included talking to coworkers who were not supervisors, but also bringing issues to managers and also to national officers of the organization in an effort to get them to persuade Smith to stick to the commitment to the employer's commitment to sponsor Asensio's work authorization so that she could be rehired. In the course of some of these discussions, she allegedly said that Smith was racist as well. So ultimately what happened here is that she gets essentially discharged. There's an investigation into whether or not she called Smith racist, which the employer's investigation discloses that he was not racist. Actually, that's what the investigation was into, her claims that he was. The employer found that he didn't engage in any improper behavior. So it turned, to her and said, well, there's nothing that says he was racist and you can't do this. You broke the employee handbook rule that constitutes harassment, that you made such incendiary comments. And so we're going to have to let you go. So they decided to let her go and she ultimately resigned. So the question there is, was there mutual aid and protection? Was her conduct engaged in for the purpose of mutual aid and protection? There was no question that it was concerted, really, at least to the insofar as she spoke to coworkers about it. But was it for mutual aid and protection? There was a case at the time that held that advocacy on behalf of others who are not statutory employees is not for mutual aid or protection. So that was an Amnesty International, which involved where the board said that acting on behalf of non-paid interns, employees who acted on behalf of non-paid interns who worked in their office were not engaged in concerted activity for mutual aid or protection. The board in American Federation said, no, that was incorrect. Well, first of all, it said that Asensio, in fact, was a statutory employee, even though she was not currently authorized to work, which is immaterial, but it recognized that there are case laws that hold that people who are applicants for hire are employees within the meaning of the act. That's without question under board law. So the board first said that she actually was an employee, but more importantly, notwithstanding whether she was or was not an employee, that Ray Bond's attempts to have her to persuade the employer by, talking to her coworkers as well as going directly to management by trying to persuade them to rehire her and to stick to his commitment to do so was actually qualified as activity for mutual aid and protection under two theories. One being the solidarity rule, which sort of says that, you scratch my back or I scratch your back today and you may come back and scratch mine later when I need help. So that typical example is one employee, gets disciplined or gets discharged or there's some adverse action and everyone else comes to that employee's aid and they they demand that the employer, hey, you should rescind this or this isn't fair. So they don't have a personal stake, but they make common cause with this employee. I'm kind of conflating the two because there is a common cause theory too, but they say, hey, we're going to help you. And when something happens to me, everyone else will help me as well. So that's sort of the solidarity principle. And then there's also making common cause with employees. So under that theory, you help they could either be similarly situated employees or they could be employees who work for another employer whose terms and conditions or whose benefit in the workplace may inure to you somehow. So there are cases where even if you do something for employees for another employer, the board has found that constituted mutual aid or protection. A couple of examples. I really thought I would get through more than just a few of these cases. Let me get to it. In one case, there were employees who protested their employer's efforts to undermine a cooperative of dairy farmers. And not only were they not employed by with these employees, but they were also not employees under the act. And then there was another case, General Electric. In this case, is from 1968. The board held that employees were engaged in protected concerted activity when they collected money at their employer's facility in order to support the organizing efforts of non-employee agricultural workers, who obviously didn't work for the company. So the takeaway there, the board said, the relevant question in cases like this, in short, is not whether the person that employees seek to help are statutory employees themselves, not whether they are like statutory employees, and not whether they have any particular relationship with the employer. The question is simply whether in helping those persons, employees potentially aid and protect themselves, whether by directly improving their own terms and conditions of employment or by creating the possibility of future reciprocal support from others in their efforts to better working conditions. 1249 Home Depot. So what I'll do is just make a quick remark about Home Depot since I don't have much time. And then I'll get to the rule, the election rules. I think I can sum up pretty quickly because you all can also go take a look at that. So I'll get into Home Depot real quickly here. I think it's very interesting. And I think a good case to look at when you're examining the issue, one thing is a lot of these cases, I think all the ones I've discussed thus far arose during the pandemic, when many folks, you had many folks who were either working from home, not leaving home, and then you have folks who were considered essential who were in the workplace. So some of these cases arise for folks who are considered essential and are still in the workplace, including Home Depot. So this Home Depot case, I think will be interesting for those of you who, are presented with issues where you have, what can be considered a provocative display by employees in the workforce. In this case, this employee on his or their rather Home Depot apron, many of us all of us are probably familiar with Home Depot, had written BLM for Black Lives Matter on their apron, and that was specifically in response to the killing of George Floyd. Initially, this employee only worked for Home Depot for 6 months, and almost from the time that they began work for the employer, they noticed that there was this one supervisor who they believed was displayed racist behavior towards people of color, both the employees as well as customers. And he was, or they weren't the only employee who noticed it. They discussed it with other employees. These other employees discussed it among themselves, and in some cases they brought these issues to like the assistant store managers. Initially the employer did, so the facts here, the employer was responsive in some ways to these complaints, meaning that ultimately they at one time they had a counseling with this supervisor, and then they gave them a written warning sometime in December. So this all starts in August of 2020. And in December, they discipline this supervisor, but they don't tell the employees that this has happened. So, but they do take some corrective action. Fast forward to February, it's Black History Month, and the employees hang displays for Black History Month. the display gets vandalized. The employer comes out, assistant store manager says, no, that was wrong. It won't be tolerated. The display is put back up. It's vandalized again. And again, they issue an email. So as I mentioned, they were responsive. They tried to address some of the complaints, but that wasn't enough for the discriminantee in this case or their coworkers. And so they wrote an email. They engaged in some activity where they said, hey, it's great you wrote those emails, but we want an open discussion surrounding what has been going on here. It's been going on for months and you're not addressing it. And they subsequently, the management has a meeting with this employee and they say, okay, yeah, they acknowledge we've not maybe done as much as we could. We're going to do better. But the facts established that this manager that called the meeting was clearly aggravated over the email about we need to have open discussions because the manager thought it had been widely distributed among employees. So shortly after they sort of acknowledged the issue or acknowledged that they could do better and that they will, they moved to the BLM letters that are written on his apron and they say, hey, that violates the employee handbook, the dress code. And also it is could be offensive to other employees. If we allow that, we'd have to allow employees to wear swastika if they wanted to wear. That's one of the things that the manager said to this person. And so the person said, and they said, isn't there a better way? By the way, I think this is relevant. This person was Mexican and Hispanic, but said that they were in solidarity, with Black employees and other employees of color. And so the manager asked, wasn't there another way that you can show, your support and your solidarity? And they said, yes, there is, but this is one way that I can show it as well. And they insisted that I'm going to continue to show it in this way as well as do these other things that I've been doing. And ultimately the manager says, well, you can't come to work with that on your apron. They give the employee sort of the rest of the day to think about it, and the employee says no. They insisted on showing their support for their coworkers in this way and did not come back to work. So the ALJ in that case did found that was not that activity was not protected concerted activity because it was for political purpose outside of the workplace and didn't concern terms or conditions of employment. It wasn't to improve the workplace, but rather was connected to the political movement of Black Lives Matter. The board disagreed and said that and pointed to the issues with racial discrimination in the workplace that the employees had raised, which concerted or group attempts to end racial discrimination, and the board has recognized that is protected by the act, and that it related to that, and that it was not just political or external to the workplace, and that there was a linkage. So the question was it a logical outgrowth? There was clearly group activity around this particular supervisor's conduct towards employees and customers, and employees had complained about it. The question was it a logical outgrowth in February? From the employer's perspective, this had been resolved in December when they disciplined this employee. Now, there was no evidence, at least I didn't see any, that particular supervisor was the one responsible for the vandalism. So that vandalism was just sort of what triggered the renewed group activity, which was the email. So I see it's almost 1. I'm going to wrap up because I said I'd allow time for questions, but I'm going to use just a minute to sort of wrap up the other things I was going to talk about, which again, I can send materials to everyone just so you all will get everything and have all of the the references that you need sort of to get up to speed. We have been living with a lot of this for for some time since August, but we haven't had a lot of cases decided under the rules handbook. So that's one of the ones you'll want to sort of watch out for if handbook rules are of interest to you. I imagine those decisions will start coming down when the board, starts churning them out or gets ready to churn them out. So I'm going to wrap it up there, but yeah, take a look at Home Depot, especially for the nuance. And especially because so many people bring into the workplace, you know, so many issues outside of the workplace affect issues within the workplace. So that one will probably come up a lot within that setting. As far as the newly amended rules governing representation elections went into effect on September 30th, for those of you who don't know. This was like the third iteration of rules. So there were the 2019 rules, which were amended in 2022 and then amended again in July of 2024 with the Fair Choice Employee Voice final rule that the board issued on July 26, 2024, which changed it in 3 respects. One of the biggies is that blocking charges are back for those of you who handle representations cases, who are representing employers or unions and filing petitions. Those were the 2019 rules did away with the blocking, basically, in most cases. I haven't seen a block case since 2019. And the new rules restore regional directors' use of blocking charges. So I think that's the biggest. There are 2 other aspects or 2 other amendments, but that's a big one. It is 1, so that time flew by.
Yes, it did. But you gave us a lot of information. Thank you so much for all of
Whoa.
that.
So yeah, if you have time for questions, I'm happy to take any. Christine, if you guys have to move on, that's fine as well.
Well, if anyone has any questions, if they want to just raise their hand or put it in the chat log, shout it out. Does anybody have any questions for Ms. Clark? Not seeing or hearing anything.
Okay.
So I guess we'll go ahead and do like you said. I will wait to get some handouts from you or links, and I will send those along with the survey that you guys will receive regarding today's event. Thank you so much for attending. If
Okay.
you could, we appreciate it. It was a great speech. Thank you very much for all the information.
Thanks for having me
Um,
back. It's harder to squeeze in these days.
we
But
understand, but
but
you've
we
always got great information for
yeah,
us.
but
So thank you.
I do like coming to address you all and try to squeeze it in. So thanks for inviting me back.
Thank you for coming. And for our members, we will have another meeting next month. Next month's will be in person at the State Library of Ohio. It will be Mr. Christopher Green, who's currently a partner with the firm prior to this known as Crab Brown. And he will be speaking on federal and state discrimination, harassment, and retaliation in the workplace claims. So we look forward to seeing you next month. And otherwise, please go ahead and log off. Thank you so much for coming today.